5 seconds. The services of some of them had been terminated within 1 or 2 years from the date of temporary appointment, though the state had taken a decision to terminate all those who were appointed on consolidated wage basis. The other respondents continued because of the interim orders by courts. Service for a period of 1 or 2 years or continuation for some more years by virtue of final orders under challenge or interim orders would not entitle them to any kind of relief either with reference to regularization nor for payment of salary on par with regular employees of the department. If there was a one-time scheme for regularization of those who were in service prior to 1/5/1995, there cannot obviously be successive directions for scheme after scheme for regularization of irregular or part-time appointments. The first matter relates to persons temporarily appointed as assistant superintendents in 1985 and 1986 in added hostels. The prefix assistant was omitted in 1996 and thereafter the respondents were known as superintendents. The second matter relates to a person temporarily appointed as a superintendent in an added hostel. They filed writ petition contending that they were employed on full-time basis and were discharging functions similar to those of superintendents in government hospitals but were being paid on a merged salary while their counterparts in government hospitals are paid much higher pay scale in the category and hostels and in category C hostels. They sought regularization in the post of hostel superintendent from the date of initial appointment and payment of salary on par with hostel superintendent of class C hostels of the social welfare department. The respective respondents in the remaining 8 appeals claim that they were appointed in the years 1995 to 1998 as part-time cooks and chowkidars in government hostels run by social welfare department. They claim that their appointment orders were issued by the respective mess committee of the hostel where they were employed, that the state government was paying a fixed amount of rupees 600 per month in the form of aid to the concerned hostel mess committee, which in turn was being paid to them as remuneration. The state government issued an order dated 28/12/1998 stopping the practice of appointing class 4 employees on consolidated wages and to remove any person appointed on the basis. By subsequent circular, the district social welfare officers were directed to remove part-time chowkidars and cooks employed by the department with immediate effect and replace them by ex-servicemen or widows of ex-servicemen. In view of the government directives the respondents apprehended, their services may be dispensed with. In the first 7 appeals, a learned single judge by a common order allowed the writ petitions. He held that the writ petitioners working on the posts of superintendent, cooks, and chowkidars are entitled to salary on par with the salary which was paid to their counterparts holding similar posts in the hostels run by the Social Welfare Department of the state government with effect from the dates of their respective writ petitions. He also held that any attempt to terminate the services of employees working in the hostels on consolidated salary was unjust and illegal, and therefore the writ petitioners should be permitted to continue to work on the posts which they were holding as on the date of filing their respective writ petitions. He directed the state government to frame a scheme on the same lines in which the state government had earlier framed a scheme relating to part-time cooks and chowkidars who were serving as on 1/5/1995. He also quashed the order which directed chowkidars and cooks employed on consolidated wages should be removed with immediate effect and should be replaced by ex-servicemen or widows of ex-servicemen. The scheme referred to by the learned single judge was the scheme which was framed by the state government in pursuance of the directions of the Rajasthan High Court in Ans Kalyan Samaj Kalyan Sangh Supra, which was approved by this court in 1996 in State of Rajasthan versus Mod Singh. Feeling aggrieved, the state filed appeals which were dismissed by a common judgment dated 16/8/2004. The said judgments are challenged in the first 7 appeals by the state and its functionaries. In the next 2 appeals, a learned single judge by common order allowed the writ petitions of the respondent in terms of the following directions issued in Anskalin Samaj Kalyan Sangh Supra. It would be just and proper to equate chowkidars and cooks employed in the hostels run by the government or government aided institutions.